Oh, the sharing is not turned on for me.
Try it now. Yeah, I can see it.
Okay.
Yeah, and it's 1 o'clock, so whenever you're ready.
Okay, great. Well, hi, everybody. Welcome back to our Student Rights Conference. We're now in the home stretch. We're in the afternoon of our Friday session. So it's great to see everyone back. Hopefully, you've had an opportunity to get some lunch and rest and relax a little bit. And now we're going to go ahead and talk about high school sports. My name is Kathy Mahoney. I am wearing a blue blouse with glasses, which I will most likely take on and off throughout the presentation. And I have blonde hair, supposedly. It's not really blonde, but that's what color it is dyed to look like. I'm an attorney here at Abner Waker. I work in Pennsylvania. I handle cases all over the state, all manner of student and educator and administrator type of matters, including Title IX matters. And a quick fun fact about me, I just got back day before yesterday from 10 days in the UK and Ireland. So I'm a little jet lagged, but I'm going to push through today. So I'm going to be talking to you about the law as it pertains to high school athletics. And to get us started, I thought it would be interesting if we just have a little warm-up video. This is a guy who posts videos on TikTok and on YouTube. He's a school teacher and a coach. So just want you to listen to his video and then tell me in the chat, are you this parent? Or do you know anyone else who is this parent? Okay, here we go.
Email from the parent to the coach. I absolutely love when people send me these, one, because they crack me up too on the coach. So you can relate in some aspects. They're so funny. So this one was sent to me from a softball coach that he got from a parent. I'm going to read it to you. You tell me what you think in the comments. Here we go. Coach, just wanted to check and see why Madison only played 3 innings this weekend, despite the fact that she had a great attitude and out-hustled many other players. I paid for team fees, game fees, hotel fees, parking fees, concession stand fees, and $8 Gatorade just like everybody else. I'm struggling to understand why she wasn't given an opportunity to play shortstop, third, or even be a DH. Also, I noticed you smiled at another player's family after the game. I don't want to start drama while people are talking. Also, I noticed during the second inning that you said, good job to another player. While I support team unity, I do think we discussed favoritism. I don't know if you noticed, but there have been defensive mistakes made by other infielders since March. You'll notice Madison wasn't responsible for any of them because she wasn't on the field. Please let me know what tomorrow is for her moving forward. Respectfully, a concerned parent. Comment?
Okay, comments. Let me know in the chat. Is this you?
Kathy, we don't have a chat today. We do have a Q&A, and we're trying not to use that as a chat, but you may be able to hear from that later on, unless it's a poll.
I might have just been
Okay.
able to enable the chat. I don't know if anyone who's an attendee can try it. Yeah, we'll just enable it for this moment if everyone wants to answer. If Kathy, we want to repeat your question.
Sure. Does this sound like anyone you know? Are you this parent? Or have you encountered this parent in your travels on your kids' teams? And Mark says that's not him. Not it. Well, thank you guys for your comments. Everyone says it's not me, but I do know who this parent is. So what we're going to talk about this afternoon a little bit is, I've been getting in my practice more and more of this type of consult with a parent who feels as though their child is not being treated fairly, or there's some other problem going on with the coach, and they want to know what their legal options are. And I felt like I don't think there are that many legal options, but I'd really like to take a deep dive and find out for sure. So that's what we've done in preparing our presentation for today. We've actually scoured, as we get into this, we have scoured the United States to look for cases where a coach was sued by a student athlete for some type of bad behavior. And what we found in general is that very, very, very few cases are successful. So before I go forward, I just want to let you know a couple of parameters. So today we're going to focus on K through 12 athletics. We're not focusing on college level athletics. And we're also focusing on athletics that occur within the public school context. So I know that a lot of kids participate in like travel teams and club sports and things like that. We're not really going to be focusing on that today, although some of these principles that I'm talking about will apply there as well. Okay. So just to start us off, athletics is not an escape from education. They are an education. So why is this topic so important? Well, let's take a quick look at some of the facts and figures about high school athletics. So according to the National Federation of State High School Associations, in the 2024-2025 school year, we had more than 8.25 million students participating in high school sports. That's the highest number ever recorded in the United States. You can see here that it's split more boys than girls, but it's not that huge of a difference. And we've got conflicting statistics available on what percentage of students participate. One report that I read said 30 to 35% of all high school students participate in at least one interscholastic sport. Another study found a higher amount, 57% participate in one sport. But here's another interesting fact and another interesting statistic. Of this roughly 8 million student athletes that we have at the high school level, only about 560,000 go on to compete at NCAA schools. So what that tells us is that for the vast majority of our children, their athletic careers are going to stop, at least at the competitive level, will be over at the end of their high school experience, which makes it elevates the stakes even more for those students. All right, let's talk about the benefits of participating in sports. So, studies show that students who participate in interscholastic athletics often earn higher GPAs, have better school attendance, are more likely to graduate from high school, develop stronger time management and organizational skills because they have to balance academics with their practices and their games. They learn discipline, goal setting, accountability. And while participation alone does not guarantee these outcomes, athletics, there is a strong correlation between participation in athletics and academic success. Physical health benefits, of course, we know that improving cardiovascular health, developing lifelong exercise habits, reducing the risk of obesity and its related conditions, improve coordination, balance, motor skills, learning about nutrition, injury prevention, and healthy lifestyles all come from participating in athletics. We also see a strong correlation between participating in high school athletics and mental and emotional benefits. We see a correlation between athletics and reduction in stress and anxiety, improved self-confidence, self-esteem, building resilience, right? Teaching students how to respond to setbacks, how to respond to failure, how to respond to losing, even when you work really hard. Fostering perseverance and a growth mindset, and also giving them that sense of purpose and belonging. Now, like any other activity, it can also create stress. So we'd like to see a supportive coaching and healthy team culture to help with that. Lastly, we'll take a quick look at social benefits. So there's a strong correlation between participation in athletics and developing meaningful friendships, learning teamwork and collaboration, building leadership abilities, especially if you're a leader on your team and you have that experience of being like a team captain or co-captain. Um, you learn to interact with peers from different backgrounds. You learn to experience mentorship from coaches, from older teammates, and you then have these interpersonal skills that you can transfer. They're transferable into college life, work life, and just your life as a citizen and a member of the community. Okay, the stakes. What's at stake here? Well, colleges and universities awarded $3.7 billion in athletic scholarships yearly. And we recently had a case called House versus the NCAA, where the court ruled that major conferences are now allowed to directly pay athletes. And that included a $2.8 billion back damages payment to past athletes and a cap of roughly $20.5 million per year to share with active athletes. And also, as part of that, the NCAA now permits athletes to monetize their personal brands through endorsements, appearances, autographs, and social media without sacrificing their college athletic eligibility. So that you can see, folks, that the stakes are really high here for some of these athletes. Some of these high school level athletes that have designs on graduating up into the NCAA system really do have a lot at stake. And their parents take this very, very seriously. So this only serves to intensify the importance of high school athletics for many students. So that begs the question, what happens when things go wrong? And I just want to give you some of the typical complaints that I see in my practice. I see our potential clients are coming to us saying, the coach is not giving my child enough playing time. The coach yells at, embarrasses, or bullies my child, or singles my child out. Or the coach is showing favoritism to another player, or the coach prioritizes winning over player development. Or this is one that we hear a lot, the coach is retaliating against my child because I complained about them. I complained about the coach. I complained about the assistant coach. I complained about the pizza party, the Secret Santa gift exchange, all of that kind of stuff. And I complained to the principal, and now the coach is retaliating against my child. So these are the types of complaints that we frequently see. And we're going to talk a little bit about when will the law intervene in these situations and when won't it. But before we do that, let's do a really quick question. Did you participate in a sport in high school? And if so, did your coach ever yell at you? And I don't know if we have this set up as a poll question, but if not, we can just answer in the chat again. Let's see. Renee or Elizabeth? Oh, there. Okay. So we do have a poll question for you. Yes, my coach yelled at me. No, my coach did not yell at me, or I didn't play a sport. Oh, that's interesting. So we got pretty even results. Some people didn't play a sport, and for those who did, they said their coach, some of them, their coach did yell at them, some the coach did not. I'll just share with you that in high school, I did track and field and I did cheerleading, and I got yelled at in both sports, but I think I deserved it. Most of the time, I was goofing around and not paying attention. So I would say that that was deserved yelling. All right, let's talk about what our parents can do when there is a problem with the coach. Can we sue? Can we sue the school? Can we sue the coach? That's usually what the parents want to know. The short answer, probably not. Probably not. Routine disagreements over coaching decisions, such as playing time, strategy, play calling, team selection. My son didn't make the varsity team. He should have made varsity. Um, all of those types of disputes rarely give rise to successful legal claims. Courts are generally reluctant to second guess ordinary coaching decisions, absent unlawful conduct. And basically, school districts are typically immune from these types of suits. So, what we did was, I said at the beginning, we did a nationwide scouring for case law. What I'm going to do now is just pull out some of the more interesting cases we found from our jurisdictions that our law firm represents. So, we're going to take a look at some Pennsylvania, Ohio, Michigan cases. But let's start off with this general premise that I think parents need to understand, which is students do not have a constitutionally protected right to play sports. That is the current state of the law in all three of our states. Therefore, it's very difficult for the parents or the child to raise a claim that their rights are being violated by the coach. You don't have a right to play the sport. Playing the sport is considered a privilege, not a right. So, with that as our backdrop, let's take a look at a couple of cases. First one we're going to look at, Chisholm versus St. Mary's School District Board of Education. This is a Sixth Circuit case from 2020, and it comes to us from the state of Ohio. In this situation, we had two former high school football players. They alleged that their coach repeatedly used vulgar and degrading language, including the term, you can read it on the screen, they used that term to insult and motivate them in front of teammates. They asserted Title IX, which is a federal claim, and an Ohio state law claim for intentional infliction of emotional distress. So the issue here is whether the vulgar and gendered verbal abuse by the high school football coach supported liability under either Title IX or under Ohio State Court. And let me just say here that I think it's relevant for us to think about the word. I hate to say the word, it's so vulgar. You can read it there, but it does imply a an element of gender, like an element of gender is injected into that word. I think that's relevant because I think that's why the parties filed the Title IX complaint. As you've heard in our other presentations throughout our conference, Title IX is a federal law that prohibits discrimination on the basis of sex or gender. So, did the court rule that that violated Title IX? The court ruled did not. So Title IX requires sex-based discrimination, not merely crude or offensive language. And they basically held that, okay, yeah, the word may have an element of genderness inherent to it, but it's really the court perceived it as a criticism of the player's toughness in a football setting. And it was not unequal treatment on the basis of sex. So therefore, it's not a Title IX violation. And it's also not a violation of Ohio intentional infliction of emotional distress law. And for those of you who are non-lawyers in the audience, I'm sure all the lawyers already know this, but there is a tort in all three of our states, most likely all 50 states, for what's called intentional infliction of emotional distress. But that tort is quite limited and is only available for conduct that is extreme and outrageous and goes beyond any bound of decency and causes severe emotional distress. So these types of claims are filed all the time in every state, and courts will frequently dismiss them unless it's extremely, extremely outrageous conduct. So for me, I'm not surprised that that claim got dismissed here because while this is a vulgar word, it's not very nice. Some would say it's not good coaching. It doesn't rise to that level of extreme and outrageous conduct that we would expect a court to uphold. So, like I said, I'm not surprised that the Ohio IIED claim was dismissed, but I was a little surprised that this didn't make it through Title IX. But anyway, just so you can see an example of where the students dissatisfied with the coach, don't like the way the coach was behaving, file a lawsuit, the lawsuit is thrown out. Okay, so let's take a look at in what circumstances will the courts step in? So the courts will typically intervene if a coach has violated a criminal law in like physically abusing a student athlete or sexually abusing a student athlete, or if a coach has violated a state or federal sexual harassment law, such as Title IX, or if a coach has violated a state or federal anti-discrimination law, such as Title VI, or if a coach has required a student to play despite a serious injury. Or finally, if a coach retaliates against a student for engaging in a protected activity, like exercising their First Amendment rights. But as we're going to see, that's even a difficult case to win. So what I'm going to do now is just go through a couple of cases that were brought under these situations, and we'll walk through how the courts handled the cases. So the first one we're going to look at comes from my jurisdiction. We are in the Third Circuit Court of Appeals, and we're in Pennsylvania, Mann versus Palmerton Area School District. So in this case, we've got a Pennsylvania high school football player that alleges that his coaches required him to continue practicing after a violent hit and possibly having visible symptoms or signs of a concussion. The testimony that came out during the discovery phase of this case, we've got a 17-year-old student. He has a hard hit to the upper body during football practice. After that, he is dizzy, visibly dizzy. He's stumbling on the field. The coach asks him if he's okay, but makes him continue practicing. And then he receives another hard hit about 20 plays later. So we have the initial hard hit, we have the initial symptoms potentially of a concussion. Then he goes through 20 more plays. Then he has another very hard hit, and that results in a traumatic brain injury. So the question here was whether the student athlete in this contact sport has what we call a substantive due process right not to be exposed to further harm by a state actor. So again, just for the non-lawyers, basically he tried to argue that he has a right as a citizen of the United States under the 14th Amendment to the United States Constitution not to be exposed to further harm by a state actor. A state actor is someone who's acting on behalf of the government. In this case, because this is a public school, the coach of the public school is the one acting as a state actor. The court actually did rule in favor of the student, which is interesting, and said, yes, you have a constitutional right to be protected from further harm when a state actor requires exposure to violent hits. However, there's a big but here. Yes, you have a right not to be exposed to further harm, but the coach in your case did not necessarily understand or know that. And because he didn't understand or know that, he's entitled to what we call qualified immunity. And qualified immunity is a limited immunity in the law that we give to government actors, to people who act on behalf of the government, where we essentially say to them, look, you're acting on behalf of the government. You are not allowed to violate citizens' rights. And if you do, you could be held liable. But if you can show that you did not clearly understand that you were violating a protected right at the time of your actions, then we're going to give you a limited immunity where you cannot be sued. So we're basically going to say, okay, you shouldn't have done this, but you didn't really know that you weren't supposed to do it, so we're not going to hold you liable. So that's what happened here with this coach. So this coach was held not liable. But what this did do was it set the stage for future cases, because the next coach that ignores symptoms of a concussion and requires the student to play is not going to be able to say, I didn't know. I didn't know that my player has a right not to be exposed to further harm. From now on, in my circuit in Pennsylvania and Delaware and New Jersey, the law is if you're the coach and you are aware that your player may have been exposed to a concussion and you continue to play that player, you could be held liable for any injuries. So it's putting more responsibility and more onus on the schools and their coaches to make sure that they're paying attention to the health and safety of their players and potentially imposing liability for not doing so. Okay, next case. This case is out of the Sixth Circuit. It is from Tennessee. Lowry versus Uverard. And in this case, it was pretty interesting. We had 4 high school football players who circulated a petition seeking the removal of their coach. And I'll just let you know, the petition said, I hate Coach Everard and I don't want to play for him, period. So here's what happens. The coach catches wind of it and he kicks those 4 players off the team for circulating the petition. And not only that, he questions everybody else, and anybody else who doesn't cooperate, they also get kicked off the team. So, of course, these kids' parents, they file a lawsuit and they're like, they have freedom of speech. They have every right to circulate this petition if they want to. Now, what do you think the court held? Was it protected free speech or not? And I know that you guys, we've talked a lot about free speech in our conference this year. We had Nicole talk about it yesterday. We had Liz talk about it a little bit today. We know that the seminal case on student free speech is Tinker. And Tinker says that students have free speech unless it would cause a substantial disruption to the orderly operation of the school, right? I would argue that circulating this petition isn't going to cause any substantial disruption. It should be free speech. I was shocked to learn in this case, the Sixth Circuit issued a scathing opinion. And they actually, in my opinion, deviated from Tinker. And they said, you do not have a First Amendment right. Your right, you have a right to a public education. You do not have a right to play sports. So If you don't like the coach, then you can decide not to play the sport. Um, if you don't like it, you don't have to play, but you don't have the right to circulate the petition. And the coach was within his rights in kicking these players off the team. It's like bizarro world to me. I'm like, what? But that's the law, you guys. That is the law. So we have to just keep that in mind. When our parents come to us and they're frustrated with the coach and they want to get the coach fired and they want to sue the school district, the case law, unfortunately, is not on your side. All right, moving on. We're going to go swing back to Pennsylvania now. Now, this case that I'm going to talk about, Spady versus Bethlehem Area School District, 2015 case out of Pennsylvania. This is a tragic case, and I included it in my presentation because I wanted to talk about the holding of the case, but this does not involve a coach in a high school athletic situation. This involves a teacher who was a physical phys ed teacher. So we have a mandatory swim practice as part of gym class. Our plaintiff is a 15-year-old student. He was a non-swimmer. He was forced to go into the pool. While he was in the pool, he ingested water into his lungs. He got out of the pool, told the teacher that he was having chest pain. The teacher ordered him back into the pool where he had to finish the class. And then about 90 minutes later, our 15-year-old student went to his English class and he died of something called secondary drowning, which is something I was not familiar with, frankly, before researching for this presentation. But apparently, secondary drowning is something that can happen when water does get ingested into your lungs, like what apparently happened to him. So he unfortunately dies, and his parents bring a lawsuit against the teacher and the school district under various theories. So we've got Section 1983, which is a portion of federal law that allows private lawsuits for civil rights violations. We also have a claim for a violation of the 14th Amendment due process clause. And we have something called the state created danger theory. The state created danger theory is a lawsuit that a parent can bring, or really, anyone can bring it when they want to argue that the state, the government, somehow created the dangerous situation that led to the injury. So it's typically an exception to the idea that in general, state government actors or just government actors in general are not required to protect you from harm. If they are the ones that create the dangerous situation, then they can be held liable for not assisting. So I need to just tell you that this case then goes on two different tracks. We're going to focus on what the court said about the coach. And then at the end, I'll tell you what they said about the rest of it. So in this case, the court held for the coach. And the court held there was no clearly established right to dry drowning intervention protocols, which is what could have maybe saved our plaintiff's life. And the court compared this case to other similar cases and found that in other cases where a student died or was severely injured, where they did find liability, there was some type of egregious, intentional misconduct on the part of the state actor. In this case, we didn't have any intentional misconduct. This coach obviously did not intend for this to happen, did not act intentionally, and therefore was not liable under any of these theories. So the court dismiss the coach from the lawsuit. And then I checked the docket to find out what happened with the rest because the parents sued the school district, the school board, various other individuals, and all of those other individuals ended up settling the case. So hopefully the parents did get some type of settlement for this, but the court did not intervene on behalf of the student um, with regard to the coach in this case. Okay, and we've got just one more case I'm going to showcase for you on this issue. This time we're going back to the Sixth Circuit. This case arises from Michigan, and Henderson is the plaintiff, and it's versus Wild Lake Consolidated Schools. So I'm going to have to spend a little bit of time going over these facts with you because it's so outrageous that if I don't share all these facts, I don't think you're going to get the full flavor of what really went on here. So let's just walk through it. The plaintiff is a high school junior named Teresa Henderson. The defendant is the soccer coach. His name is Russell Crawford. And then the other defendants are the school district, the school superintendent, the principal, the assistant principal, the athletic director. But a little bit of information about Mr. Crawford, the coach. So he was hired in 2002 at age 29. He passed an interview, reference checks, and a successful criminal background check. Then he's hired. From the outset, he quickly established himself as in charge. He threatened to cut players' playing time if their parents complained. He also told Teresa, our plaintiff, that she had been the team captain the previous year. He said, "You will not be team captain this year because you have an attitude." He also frequently used obscenities and vulgarities and spoke to the players in a demeaning way, while at the same time engaging in flirtation and making sexually suggestive remarks to the players. He would invite the players over to his house for team meetings, and he was known to contact the players at unusual hours, late at night, by phone and by email and by text message. So I'm sure you can guess where we go from here. He became especially interested in another one of the players on the team named Jill, and he even communicated his desire for Jill to Teresa. Teresa discouraged him from pursuing Jill, but he ignored her, and he even threatened the entire team with consequences if anyone disclosed the relationship with Jill. In early to mid-April of 2002, Jill's parents become concerned about late night conversations between Coach Crawford and their daughter. So they express these concerns to the assistant principal. The assistant principal promptly has a meeting with Coach Crawford, the principal, and the athletic director. They talk to him about this. Of course, he denies any wrongdoing. But as a result of this meeting, they issue him a memo with 5 restrictions placed upon him. Number 1, he cannot communicate with any players between 9:30 p.m. 7 a.m. Number 2, he cannot send any emails to players without copying the assistant principal on them. Number 3, he cannot counsel or discuss with team members any of their personal matters. Number 4, he cannot conduct any off-campus team activities without a parent present. And number 5, he must refrain from engaging in any relationship which might be perceived as inappropriate. Okay, so they give him this memo. There's these 5 restrictions placed on it. These restrictions prove to be completely useless. Within 2 to 3 weeks after the memo comes out, we have several noteworthy instances. Number 1, another freshman on the team, Shannon, came to Teresa and told her that Crawford had asked to touch her genitals. Teresa, a few weeks later, was asked to serve as a lookout on the team bus as Crawford huddled with Jill under a blanket. And then, as she exited the bus, Jill looked shocked and upset and told Teresa that the coach had kissed her, fondled her breasts, placed his hands in her pants. And then shortly after that, Jill informed Teresa that she had broken off the relationship with Coach Crawford and told Coach Crawford that her decision in part was based on Teresa's recommendation. This made Coach Crawford furious. He threatened to hurt Teresa. He said he would break her nose and take out her knees so she would never play soccer again. Crawford told Jill that the only reason Teresa was trying to break them up was because Teresa wanted him. And then he angrily confronted Teresa on the playing field in person and threatened not to coach the next game if she did not fix things between him and Jill. He said he would also hunt her down and fix it so she'd never play soccer again. She goes home, tells mom and dad, Teresa tells mom and dad what's happening and that she has been threatened by Coach Crawford. So the parents of the soccer team convene a meeting at one of the parents' houses to discuss this situation. During this meeting, they receive a call reporting that Coach Crawford had a gun to his head and was threatening to commit suicide. Police go to his home. They recover a pistol from his residence, and then they transport him to the hospital for evaluation. He then resigns. However, he is also terminated. Like, he resigns one day, but then the next day he is terminated by the school district. At this point, Teresa transfers to a different high school for her senior year. All right. That's what happened here. Those are our facts. So Teresa brings a lawsuit against Coach Crawford, the athletic director, the principal, the assistant principal, the superintendent, the school district, and the high school. She brings claims for sexual harassment and sexual discrimination under the Michigan's Elliott Larson Civil Rights Act and Title IX. She also brings tort claims for assault, gross negligence, intentional infliction of emotional distress, slander, violation of the Michigan Constitution, and retaliation. All parties except for the coach move for summary judgment. In essence, they asked for their case to be dismissed. The court granted it. The court held that summary judgment was appropriate. All parties except the coach are dismissed from the case. I just take a moment and let that sink in. There's no liability on behalf of any party except potentially the coach here. Why? How did we come to this decision? Well, under the Elliott Larson Civil Rights Act, there was no sexual harassment because his sexual conduct was not directed to her. Same thing with Title IX. And there's no what we call respondeat superior liability. In other words, the school district and the principal and the assistant principal and the athletic director cannot be held liable vicariously for Coach Crawford's conduct because they were not on notice that there was a hostile environment here. And what they did know about, they took appropriate steps to address. There was no gross negligence. There was no slander. There was no deliberate indifference here. Teresa got nothing. Okay, I have my 10-minute warning. So.
Oh, Kathy, you're
at
at 6 minutes now.
Okay, 6 minutes. So I'm going to wrap it up. What can parents do? You can't sue, but what can you do? You can document the conduct. You can ask for a meeting. You can ask for a meeting with the coach, the athletic director, the principal. You can ask for a meeting with the superintendent if that doesn't work. If that doesn't work, you can go to your school board. You can file if your coach is a a, a certified teacher, you may be able to file a complaint against them for educator misconduct in the state that you're located in. You can try to sue under Title IX OCR state procedures, but as we just saw, it's so difficult to win these cases. And finally, you can consider transferring to another school. But you should check those rules because most states do not allow transfers for athletic reasons, and it could affect your athletic eligibility. Okay, I have up here, I'm not going to spend time on this, but I do have each state in our little corner of the world's websites to their interscholastic athletic associations here, if you'd like to take a look at that. And then one last minute to talk about transgender athletes. We got a case ruling from the Supreme Court on June 29th, just about 2 weeks ago, that upheld the rights of states to enact bans on transgender athletes participating in women's sports. As of right now today, we have about 27 states that have state laws that ban transgender athletes from participating in women's sports. That has been held not to violate Title IX. But also, the states that choose not to have those laws banning transgender athletes, those are also not against the law. So we're really in a situation where it's up to each state to decide how to proceed. And my time is almost up, so I can answer any questions you may have, or if you would like to talk more about the transgender thing, we'll have our panel at the end of the day and we can talk about it more there. So thank you for your time. Any questions?
Kathy, we do have a couple questions. Let me pull them up. Great presentation, by the way. I think we all learned a lot. So the first question is Lowry facts, even with just for a coach, couldn't allow school discipline, correct? Under First Amendment?
Say that again.
So Lowry facts, even with just for a coach, couldn't allow discipline, correct? And then under First Amendment.
Let me look at that for a second.
I think the question might be asking, because the Lowry facts, it seemed like said that the coach could remove players or students from a team because of their free speech, but Tinker and some of the other free speech standards do say that you can't punish a student for their free speech unless the substantial disruption. So I think the question was, kind of confirming coaches can, yes, they can kick players off a team, but they couldn't suspend, like do a suspension
No,
or
suspend.
type of discipline.
No.
I think that might be the question.
Right. Thank you for that clarification, Renee. In order to suspend a student, that I think other people have talked about that earlier in our conference, but no, the coach, you can only be suspended for violations of the code of conduct. So if the only way you could be suspended is if what you were doing, like in this case, circulating the petition, if that violated the student code of conduct, then in theory you could be punished in accordance with this code of conduct, but it's unlikely.
Thanks, Kathy. And then we have a second question. It's a bit shocking that the Lowry case was not appealed to the Supreme Court given the departure from Tinker. Is this case an outlier? Is there any sign of a similar case going to Supreme Court to get clarity on free speech?
I don't know the answer to that. That's a good question. To me, it seems like an outlier. I think I showed you, I emoted my shock in their decision. the Sixth Circuit, if you want to read more about it, you can actually read the decision. It was pretty scathing, and it really honed in more on the fact that you don't have a right to play sports. If you don't like your coach, then you don't have to play for that coach. It's as simple as that. And that was really the focus of their opinion. But in my opinion, I feel as though this did not violate Tinker. But just as a really quick, just my own 2 cents in the world of Kathy Mahoney, the world according to Kathy, I feel like lots of cases are analyzed under Tinker and they could go either way. And this is one of those cases that the court went this way, and I don't agree with it. But you could find other cases out there where they also, relied on Tinker, but found that it was protected or wasn't protected. And I just don't, I don't know that I would say this is an outlier. It just stood out to me as a deviation from Tinker.
Thanks, Kathy. It looks like we might have another one. Oh, nope, I do not see another question. Oh, hold on. I'm looking at the wrong screen. I'm sorry. Even if a petition was in the student code and it wasn't disruptive to the school, couldn't it be protected?
Say that
I'm
again?
sorry. Even if a petition was in the student code of conduct and it wasn't disruptive to the school, couldn't it be protected?
Even if the petition was in the code of conduct, meaning it's prohibited under the
That's what
code
the
of
question
conduct.
says. Yeah, that's what the question says, but maybe it's the opposite.
Okay. So I'm not sure I'm 100% following that, but in general, each school has their own code of conduct and they spell out like what, is not acceptable behavior, what is acceptable behavior, and then what the consequences are for violating it. So if they put something, I've never seen a school district have anything in their code of conduct that talked about a petition. But in theory, they could, I suppose. Um, I think that a different type of petition would withstand First Amendment muster. Like if I wanted to put a petition that we should serve chocolate cupcakes every other Thursday, I think that that's completely going to be protected by the First Amendment. And I think that if that were tried to be banned by a code of conduct, that would be struck down by a court. But again, I feel like in this case, the court honed in on the thing that you're complaining about in your petition, you don't have a right to do. So stop complaining. That's the best way I can explain it.
Thanks, Kathy. It looks like we have kind of one more question. It says, we had an issue September 2025 with a middle school team player accusing another player of using a racial slur after a game in a locker room. Proof was available that it was never said, but this accusation went on for months. What can be done if this should happen again?
Well, so because it's a racial slur, it could potentially be a violation of the code of conduct. It probably is. And so there's not, there's no way to prevent somebody from making an accusation. There's a saying there's a saying in the law among lawyers, you can indict a ham sandwich, which means anybody can accuse you of anything at any time. And you can't prevent that from happening, unfortunately. If there were particular circumstances that led to the false accusation, because you're saying that it was definitely false, then I would try to, for me, if it were me, I think I would try to have a meeting with the relevant stakeholders to iron out whatever the circumstances were that led to the allegation. I would make sure there's a paper trail so that if it happens again, I can demonstrate that we've had a history of this and it's been proven false in the past to protect, the parties as much as possible. But I don't think there's any way to wholeheartedly, completely prevent something like that from happening.
Thanks, Kathy. It does look like we are over time, so we will stop you again. Great presentation. Thanks.
Thank you, everybody, and have a great rest of your day.
Thanks, Kathy. And just a reminder for all the attendees to please fill out the session 4 evaluation in the chat box. Thank you.